requires very grave consideration. It is allowed in exceptional circumstances where it is necessary that the ED is virtually remediless. That's the test. That's point number one. I propose to raise it strongly, both today and in any eventual hearing.
You are appealing for state of
I am
West
for
Bengal.
1 and 3, state and
of
police,
West Bengal.
state and DGP. 1 and 3. He's for 2. Point number 2, I also intend to raise the preliminary objection of forum shopping with your lordship's well-known case law, because what your lordship is concerned about is that this petition is filed after my learned friend files an identical petition. Lordship, take my word for it. The prayers are virtually identical.
We are in High Court and
In
here.
High Court and here. Lordship need not waste time seeing it. Lordship, take my broadly, substantially, it's identical.
Yes.
Now you are the petitioner there, you are the petitioner here. Yes, you had a fracas on a certain day, on 9th. That cannot be an excuse to maintain a parallel. My lord's concern. I don't think any of us hold brief that should.
Today it is this High Court, tomorrow the
another
High Court.
Sometimes emotions go out of hand and they can't be controlled. Please don't misunderstand me that I am not understanding my lord's concern, and that I don't think anybody will hold a brief. Perhaps emotions go out of hand and we are not able to control. But the relevant test is yesterday.
No, you see, emotions should not go out of hand regularly.
No.
In an orchestrated manner.
And then on 9-1, again, emotions go.
Now, may I just say, we are now talking of R1 and R3. I am saying this, that the relevant date for considering forum shopping is yesterday. I understand, I am not belittling what is falling from my lords. Keep that 9th apart for just 2 minutes. Yesterday, everybody was in court. It is not even your case that anything untoward happened or was attempted or even started. Why on earth, you having filed your own petition in High Court, the next day having filed in Supreme Court or 2-3 days later filed in Supreme Court, then make a statement to the High Court yesterday, and the High Court is supposed to pass such an order, anyhow. It is not that you are getting this date yesterday because of the ruckus. Kindly give a copy now. Why don't you give a copy? So, in effect, the High Court is told, I am riding 2 parallel horses. I am telling your lordship I am riding 2 parallel horses. But you please stay your hand. And the High Court records this order, 1-page order. I am adjourning it sine die. Obviously, in Committee of Courts and Superior Court and all that, it's the right thing to do. As far as the High Court is concerned, I am not blaming them. I am on the conduct. So this is forum shopping. I again take the strong preliminary objection. My third submission is the Panchnama, which has been read. That has been read, I am not repeating it, but just note the relevant words, only the operative words, 3 lines, which you have seen, Panchnama, which has been read already. It's been read, but just the relevant lines, at 66 to 69.
66?
Yes, 66 to 69. These words are important. That's my third respectful submission.
At page?
It's at page 60. This particular portion is which page?
68.
68. You also use the first file.
Yes.
Please, you don't know the thing. If your lordship, just the penultimate para at 68.
Yes.
This is relevant. Ultimately, what is relevant is this, to tell you that he snatched the papers, he ran away, he did this, he assaulted somebody. What is relevant is this, either you are lying or your petition is lying. Third, penultimate para, second line.
Yes.
The search was conducted in a peaceful, orderly manner. Each word is important. No damage to any person or property was caused during the search. Entire proceedings were conducted in the presence of lady staff and no religious sentiments were heard.
Leonard Finn may read the 2 paragraphs above.
What peaceful means? Peaceful from their side. They mean to say.
2 paragraphs above what my Leonard
It is side, not from your side. That is what probably.
I'll read whatever you want me to read. I'll read it,
Not the relevant section. Let him.
They have done it peacefully.
No.
I let him read the 2
the
paragraphs.
previous para which he asked
2 paragraphs above.
face,
While
respond
may not
Mr.
do it
Raju,
peacefully.
please.
Let him read.
It is not denied by our.
Take Mr. Raju that what he should read.
We didn't interrupt once even,
Yes,
it took a long time.
Please, Mr. Singh.
Mr. R2, Mr. Sibbal, has admitted that the CM was, the president of the party was there. So what is so great about this para? This para says that so and so time, so and so Miss MB took possession of the material, etc., etc. That's all. Nobody is denying that she was there. Now, these are derailment. I have a different point. I am saying that with this Panchnama, what you are projecting in the petition is either clearly false or your Panchnama is false. That's all I'm saying. This para is standalone, clear. Obstruction, could not do this, could not do a search, all wrong. Now, the fourth aspect is very important. My learned friend, I heard Mr. Mehta making what again is I can ascribe to mildly to wrong instructions. He said we informed them, and I believe I heard the word yesterday. I mean, the day before the event happened. I may have been wrong. I may not have heard you correctly, in which case I'm wrong. Well, it's the first and only intimation came from a casual email at.
Email can't be casual and non-casual. That's what the intimation was by email.
Have you heard my sentence fully? No, have you heard my sentence? You realize? I mean, you don't be presumptuous, Mr. Mehta. You started your search at 6:45. The email is 11:30. In which calendar, from which Gregorian or non-Gregorian calendar does 11:30 happen before 6:45? I'd like to understand that. So before you interrupt, get your instructions right. You're only, that's why I said, obviously, if I'm searching his house and I send an email 11:30 to create a paper trail, I started searching the house at 6:45, 5 hours earlier. And my learned friend says it was before and informed. In the middle of Balas, the persons are there. Some police officer will go start reading emails. 5 hours earlier, event has happened. So this is a very clever way to cover up your tracks. A person who sends an email 11:30 for a search is so inclined. Without notice, also we can put in a reply saying these points. Otherwise, like leave it to my lord.
Otherwise, you will say 6:25 p.m., 11:30 p.m.
No. I will put in these things. Lordship wants me to put
Legal
in.
things should
So
be
there
done
are other
legal way.
respondents also.
Should be done in a legal way.
Anyway, I don't know. That's all I have to say.
Yes. Yes. You're for?
I'm appearing for respondents 4 and 5.
Sorry.
In first petition.
Yes,
Because we are yet to hear the second petition.
it's in both the, it's in both the
No, Mr. Raju wants to argue the second petition.
first petition.
First petition, respondent 4 and 5.
5, yeah. So I just have a very small point. Your lordships may just consider that the appropriate order perhaps in a case or a situation like this, your lordships have seen that the hearing which took place on the 14th was in a very orderly manner. So I would respectfully submit that that is the subject matter of a 226 petition. Let that matter proceed. The lordship wants to reinforce because the Chief Justice's directions are very clear. It's proceeding in an orderly manner. It ought not to be, that's my suggestion, that the 9th January disruption which took place when the court itself could not hear the matter, that shouldn't have a lingering on the adjourned date or the next date as far as the 226 is concerned.
Only requires that prima facie a cognizable offence is made out. If the averments in the petition make out a prima facie case that a cognizable offence has been made out, that's the end of the matter. Lalita Kumari is very clear. No inquiry is required, no accused is required to be heard. The defense is not to be
You
considered
are
at that.
speaking about which FIR?
Registered and CBI investigation.
Oh, yes.
For that, I'm making my submissions. So if my petition discloses a cognizable offence, then a FIR has to be registered. Nobody hears an accused before an FIR is registered is unheard of. We have made them respondents by way of abundant caution. That is what we have said without conceding the right. That is my petition says. I've said that in paragraph of my petition. I'll read that paragraph. This is one paragraph. Now, therefore, the issue that arises is, has a cognizable offence taken place? On admitted averments, the offense of cognizable offense has taken place because an offensemen were armed and there was wrongful restraint. But forget that. Simple case of theft, which is a cognizable offense, is made out. Admitted averments in my petition. If that is so, the issue is who should investigate. If a cognizable offense, FIR has to be registered. That's the settled law in Lalita Kumari. May I read Lalita Kumari or
Yes, read.
Give me Lalita Kumari. Come to back. But kindly.
You can continue.
I'll not take much time, but I'll only make, kindly have a look at para,
You argue, we have no difficulty.
or kindly have a look at para 120 onwards, conclusions.
Yes.
By
Para 5.
120
Para 120.
at page 61. 120.1. The registration of FIR is mandated under section 154 of the code if information discloses commission of a cognizable offence and no preliminary inquiry is permitted in such a situation. So if the petition discloses a cognizable offence, it is mandatory that an FIR has to be registered.
Para 120.1.
Yes. I have demonstrated that a cognizable offence has taken place. One doesn't say that you have to inquire from the accused why you have committed the offence of theft. That